Thank you so much for joining us this evening. For those that are hearing impaired, we have two ASL interpreters, Raquel Pollock and Kim Melcher. In the chat, you will see instructions on how to lock the video or pin it for your use. And the card services link will be in the chat as well. Thank you.
Thank you, Yahira. And I want to welcome everyone to this meeting of the Civilian Complaint Review Board, our November board meeting. I'm Fred Davey, and as most of you know, I'm the chair of the CCRB. I would like to have my fellow board members, if they would, introduce themselves. And I will start with Mr. Carolina.
Demetrius Carolina, Staten Island, mayor's appointee.
Ms. Bond.
Good evening. I'm Erica Bond. I'm a mayoral appointee, reside in Brooklyn.
Right. Ms. Irish.
Hi, everyone. Corrine Irish. I am in Harlem, Manhattan, and a mayoral appointee.
Mr. Puma.
Good evening, everyone. My name is Joseph Puma. I'm the City Council designee to the board from the Borough of Manhattan, where I was raised and continue to live.
Mr. Rivadeneira.
Good evening, everyone. Michael Rivadeneira. I am the City Council's Bronx designee and reside in the Bronx.
Ms. Rice.
Good evening. I'm Arbor Rice, and I am a mayoral appointee for Manhattan, residing here in Harlem.
Great. And it's Mr. Hermit that we're missing. And is he in yet? Well, we know he's here, and we're having a little bit of technical difficulty getting him in. As soon as he's in, we'll allow him to introduce himself. It's been a busy month for the CCRB. First, I want to thank the APU, which is our Administrative Prosecution Unit, for their work on the recent trial for Sergeant Mullins. Both the department trial judge, trial commissioner, and Commissioner Shea agreed with our guilty findings against Sergeant Mullins. Secondly, last week the courts affirmed that the CCRB is the proper place, the proper entity to investigate cases of sexual misconduct and untruthful statements against members of service of the NYPD. While the police unions have fought this update for 3 years, a judge agreed that the CCRB has the broad authority to define which allegations fall within its jurisdiction, and that both types of misconduct, that is sexual misconduct and untruthful statements, fall under abuse of authority. This is a victory for the people of New York, who now have a real path to accountability if they face these kinds of misconduct by members of service of the NYPD. Thirdly, the City Council has officially introduced a bill that would allow the CCRB to self-initiate complaints. I want to thank Council Member Adrienne Adams, who introduced the bill. She's chair of the Public Safety Committee. This is a key piece of legislation that should lift the burden of responsibility off the victim of police misconduct. Misconduct should be addressed regardless of whether the people who have been affected by it have the bandwidth to act as a complainant. I will be testifying before the Public Safety Committee next week in support of the bill. John will join me for that testimony, and I hope you will all join as well if your schedules permit. It's a virtual hearing next Monday morning. Today, for this evening's meeting, our Assistant General Counsel and Deputy Chief of Investigations, Heather Cook, will present on updates in the NYPD disciplinary matrix. When the NYPD proposes changes to the matrix, there's a 30-day window for others to make comments, which the CCRB has done. Heather will give more detail on the expected and proposed changes to the matrix. The public can also submit their own requests and edits until December 5th by visiting the NYPD website, clicking policies, and filling out the comment submission form. On that note, I will pass it to our Executive Director, John Darsh. John.
Thank you, Mr. Chair. First, I want to tell people about the Youth Advisory Council. CCRB's 2022 Youth Advisory Council application period is open to all, and we are asking all 10 to 18-year-olds who are interested to apply. It is an opportunity for youth to share their voice and be part of the nation-leading police reform efforts here at the CCRB. We have regular meetings with a final presentation or summit at the end of the year. Please go to the CCRB website to apply, and applications will be accepted until December 15th. Next, CCRB has officially updated its disposition letters. We believe the new disposition letters are easier to read and provide needed resources to civilians. The letters also include information on how to file a reopen request, and samples either will be put or have just been put on the website, so that if you want to see what one will look like, you can go to our website and check it out. Before we get started this afternoon, a few quick updates on agency operations. CCRB continues to review protest cases and expect to have a protest report out in coming months. And then some ground rules for this evening. Please use the raise your hand function if you would like to make a comment, and please keep your comments to 2 minutes maximum. I would like to thank the members of the public for participating. And Mr. Chair, I believe some new, not new board members, but some additional board members have logged on since these.
Indeed. I noticed, Mr. Joseph, would you like to introduce yourself?
Yes, my name is Nathan Joseph. I am a city council appointee from the borough of Staten Island, and I live in Staten Island.
Great. Mr. Dwyer.
Frank Dwyer, born and raised in Brooklyn, live in Queens. I'm the police department rep.
Mr. Freeman. Mr. Freeman's quite with us yet. And is Mr. Merritt on yet? Not yet. All right. When they get here, we will allow them to introduce themselves as well. Before we hear from our Director of Outreach, Jahai Rose, we have to do this monthly housekeeping business, and that is approve the minutes from the last meeting. I understand there were some edits made to the minutes by board member John Siegel, and we all received his proposed revisions to the minutes. So I'll entertain a motion to approve the minutes with those revisions, if that's where we are. Is there a motion?
So moved.
So,
Is there a second?
second.
All right. Any discussion on the minutes? Any more changes, revisions, additions? Hearing none. All those in favor of approving the minutes with the proposed changes from Mr. Siegel, please say aye.
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 Any opposed? The ayes have it. The motion carries. Mr. Freeman, it seems as if your mic is on now. If not your camera, would you like to introduce yourself?
I'm Willie Freeman. I'm a police department designee.
Great. And is there anybody else I've missed? Looks like that's it. So we will turn the meeting over now to Jahai Rose, our Director of Outreach at CCRB, who will give his report. Jahai.
Thank you very much, Chair Davey. I am going to share my screen. Okay, can you see my screen?
Not yet.
Not yet, Jahai.
Can you see it now?
Yes.
Yes.
All right. Thank you very much, Chair Davey. My name is Jahai Rose. As previously mentioned, I'm the Director of Outreach for the Civilian Complaint Review Board. As you all may know, the Civilian Complaint Review Board is the nation's largest independent oversight entity over the largest police force in the country. The CCRB investigates, mediates, and prosecutes allegations of police misconduct made against officers of the members of the New York City Police Department. You've met a few of our board members. The agency is governed by a 15-member board with 5 seats appointed by the mayor, 5 appointed by the New York City Council, 3 designated by the police commissioner, and 1 appointed by the public advocate. The chair, as you've met, Chair Davey, is jointly appointed by the mayor of the city of New York and the city council. The CCRB has 4 types of allegations that we have the ability to investigate. Easy reminder is the acronym FADO, F-A-D-O, which stands for force, abuse of authority, discourtesy, and offensive language. Just to give you a little bit of information regarding the Right to Know Act. The Right to Know Act was a law that went into effect October 19th of 2018. This pertains to searches, frisks, sobriety stops, and other police encounters. This includes under certain circumstances where police officers should identify themselves by providing a name and other information such as rank, command, and shield number. With some exceptions, officers should explain the purpose of the encounter, of the interaction. They should inform you of your right to say no when asking for a consent search of your person, property, vehicle, or home. And they should also, under certain circumstances, offer you a business card with the officer's information that explains how to make a comment or complaint about the interaction with a New York City police officer. Civilians can request this business card in all interactions. This is a copy of what the Right to Know Act card looks like. There are a few ways to file a complaint with the CCRB about misconduct. 2 of the easiest ways are one by using the CCRB's website. That's nyc.gov/CCRB complaint. Also by calling the CCRB's hotline at 1-800-341-CCRB or 1-800-341-2272. Remember, if you see footage of misconduct on social media or in the news, you can file a complaint, even if you weren't there in person. Feel free to tag the CCRB in the social media video using @CCRB_NYC. A couple of additional ways to file a complaint about misconduct include calling 311. You can also feel free to file a complaint at a local precinct. It does not have to be the precinct where the incident may have occurred. You could also file a complaint by sending a letter to the CCRB or coming in person to 100 Church Street on the 10th floor. That's in Manhattan, New York, zip code 10007. The CCRB is hiring. These are the roles and responsibilities of the investigative unit. Our investigative staff is comprised of more than 90 plus investigators from various socioeconomic backgrounds that speak 10 plus languages. Our team is comprised of the best and the brightest from undergrad and graduate schools and a variety of educational institutions nationwide. If you'd like more information regarding how to apply for the investigations unit, you can feel free to check on the New York City careers portal at nyc.gov. You can also check on Idealist, which is www.idealist.org, or Handshake at www.joinhandshake.com. You could also send an email for any questions that you may have about applying for this position. You can also send an email to careers@ccrb.nyc.gov. As previously mentioned, the CCRB's Youth Advisory Council the applications are open. As John previously mentioned, the Youth Advisory Council is a group of young people that work with the CCRB. They have done phenomenal work to show us better ways to be able to engage young people and to provide information regarding how the New York City Police Department can improve interactions with young people. The age requirement for applying for the Youth Advisory Council is 10 to 18. If you'd like additional information about applying, feel free to email us at outreach@ccrb.nyc.gov. Applications will be accepted up until December 15th, and the application link will be put into the chat. If you would like a CCRB outreach presentation, feel free to email the outreach unit at outreach@ccrb.nyc.gov. Also feel free to follow us on social media on Instagram, Twitter, and Facebook. Thank you very much, Chair David.
Thank you, Jahai. Let's see if any of the board members have any questions or comments on your presentation.
I have a question. It's Nathan.
Sure, Mr. Joseph.
Mr. Joseph. Jahai, good to see you. Excellent job. I hope you know about this. The flyers that, or the posters that go up in the police precincts that list how complaints can be filed against the police department, have they been updated to include that complaints can be made at the precinct level and that the precincts are responsible for accepting and processing those complaints?
The request is in process to have those printed and sent back to the CCRB so we could deliver those to the precincts directly.
Thank you.
Any other questions or comments? I can't see everybody, so if you have one, just jump in. All right. Thank you, Jahai. And we appreciate your presentation. We'll now turn to our Deputy General Counsel, Assistant General Counsel, Heather Cook, for a presentation on the disciplinary matrix and proposed changes. Before we do that, do I see Mr. Merritt? Yes, I do. Would you like to introduce yourself, sir?
Good evening, everyone. My name is Herman Merritt. I'm the Brooklyn representative of the New York City Council, lifelong Brooklyn resident.
Great. It's good to see you. All right. So, Heather.
Thank you, Chair Davey. Good evening, everybody. I'm going to also attempt to share my screen right now. Okay, can everybody see my screen?
Yes, thanks.
Okay. So, good evening again. I'm Heather Cook. I'm Assistant General Counsel and Deputy Director of Investigations at the CCRB. And tonight I'm going to be talking to you guys a little bit about the New York City Police Department's proposed revisions to their discipline matrix. Earlier this month, on November 5th, the NYPD issued proposed revisions to their discipline matrix for public comment. The public comment time limit is 30 days. This document was 6 pages and it updated 4 sections. And so I'm just going to go through the 2 sections that are important to the CCRB, abuse of authority and progressive discipline. So under abuse of authority, the NYPD has proposed adding 5 additional allegations of misconduct: stop and question or question of a person, refusal to show arrest or search warrant, improper or wrongful questioning of a person's immigration status, failure to provide language interpretation services, and improper or wrongful damage of a person's property. The second section that they have proposed revisions to is their progressive discipline section. This is a section that deals with calculating penalty enhancements for a second or further act of misconduct. And they added clarifying language to that section, which we'll get into in a little bit. Before NYPD released these updates, the CCRB met with NYPD and we proposed the following revisions. We also proposed clarifying language in the progressive discipline section. We proposed a one-time penalty deviation option for junior officers, 7 additional allegations for abuse of authority, 1 additional allegation in the improper use of force category, and we asked for additional training and compliance for the the Deputy Commissioner of Trials, trial commissioners. So I'm going to start with the most confusing section. That's the progressive discipline calculation section. And as I said before, it's very confusing because it has 1, discretionary ranges rather than fixed penalties like the rest of the matrix. And 2, the calculations are based on the penalties that were imposed for the first act of misconduct, which was generally pre-matrix. I was going to go into a whole hypothetical about offensive language and the problems that can cause, and I'm happy to do that at the end of the presentation, but it can get a little unwieldy. So what I'm just going to say is that the calculations were very confusing. And so what could result is that your second act of misconduct could actually end up with a lower penalty than the first act of misconduct, which is in direct contrast to a system of progressive discipline. So what the NYPD did was they attempted to fix this by adding a footnote to that section. And I'm just going to read you what the footnote says. It says, in the event that the penalty in the progressive discipline schedule for a second incident is less than the presumptive penalty for the act of misconduct, the progressive penalty shall be up to the aggravated penalty or a penalty that is greater than the original penalty and is consistent with the goals of progressive discipline. So as you can see here, that footnote didn't necessarily clarify much. It made it a little bit more confusing. And we're going to just continue to sort of monitor how this is going to be calculated moving forward. What the CCRB currently does is that we take whatever penalty the board votes for the second act of misconduct and we enhance that penalty with the penalty range as it currently stands if the penalty is going to be less. So again, it's a very complicated system. I can go into it at the end, but the footnote doesn't appear to have done much to clarify. The next recommendation that we made was a one-time penalty for junior officers. And it was a one-time penalty deviation for junior officers. And this was going to be a very limited carve-out. It's something that the board sees often and that the board struggles with is when there's a member of service who's been on the force for less than 2 years. And generally this means 6 months of that was in the academy. So they've been out on the force for less than 2 years and they commit an act of misconduct, their first act of misconduct, where the mitigated penalty under the matrix would be a Schedule A command discipline, which is anywhere from 0 to 5 penalty days, and it is the lowest form of formal discipline that the department issues. The board was recommending a one-time penalty reduction to training for that first act of misconduct. This was something we suggested as a carve-out to the matrix, and it was not incorporated in NYPD's November 2021 proposed revisions. We recommended 7 allegations of abuse of authority be added to the matrix. We requested an allegation for property damage, refusal to show arrest and search warrant, failure to obtain language interpretation services, question about immigration status, which is different, body cavity search allegation, and a gun drawn allegation. And we also asked for 1 addition to the use of force allegations for gun pointed. NYPD took a number of our recommendations. Property damage is now included in the updated matrix, and the penalties are consistent with what we recommended. Presumptive penalty 10 days, aggravated penalty 20 days, and mitigated penalty of 5 penalty days. Refusal to show arrest or search warrant, same thing, consistent with our recommendation. 3 days presumptive penalty, 5 days aggravated, formalized training mitigated. Failure to obtain language interpretation services, same thing, incorporated our recommendation completely. Question became is a little bit different. It's partially incorporated into the matrix of revisions. What they did was they basically have said if the misconduct allegation is a question alone, then that will stand on its own, the question, and it'll have a presumptive penalty of 3 days, an aggravated penalty of 5 days, and a mitigated penalty of formalized training. And that is consistent with the penalties in the matrix for stop and frisk as well. But if the question occurs along with a stop, then rather than being 2 separate allegations, the question will now be incorporated into the stop. So unlike a stop and frisk, where the penalties would run consecutively, a stop and a question will have the effect of running concurrently. And that's different than stop and frisk, stop and search, frisk and search. So that was partially incorporated. We asked for it to be a standalone. Question about immigration status. This was another one that was partially incorporated into the matrix revision. The allegation itself was incorporated by NYPD, but we had asked for higher penalty. So NYPD came back with a presumptive penalty of 5 days, aggravated 15 days, mitigated training. We had requested that the presumptive penalty be 10 days, aggravated 20, and mitigated 5. CCRB asked for an allegation for body cavity search to be included in the update of the matrix, and this was not incorporated in any way. There was some discussion with NYPD when we were making our suggestions about this might be a little bit more difficult because you deal sometimes with health implications if someone's trying to swallow a substance that could be deadly. Reaching into the mouth would be considered a body cavity search, as well as other more private places on a person. And so there were some issues with that about whether or not body cavity search would just be what the penalty could be and how it could incorporate both mouth searches and other more serious invasive searches. But our suggestion was that this could have been addressed exactly the way the matrix addresses entry allegations. So if you look at the matrix, entry allegations are broken up into a number of categories. There's entry for wellness checks. There's entry de minimis, which means just putting a foot over the doorway but not fully entering. There's an entry for a substantial presence, meaning the officers went into the location. And then there's another entry for prolonged or other misconduct committed while inside. So you can see they broke up entry by the severity of the misconduct. Body cavity searches could have been broken up in that same way. And the problem with not including it is that there's no good category for us to put it in. You'll see I'll go through some of the other things they didn't include that we already have categories we can put it in terms of a force category or an abuse of authority. The problem here is that we could put it in a general abusive enforcement action, but that penalty is actually less than a strip search, and a body cavity search would be a more serious infraction than a strip search. So without even having the allegation, it's going to be very difficult for us to find a place to find a way to plead this allegation and then have it run consistent and give it both officers and civilians knowledge and notice about what type of penalty that misconduct would carry. And that was sort of the whole premise behind this matrix to begin with. So gun drawn is another one of the allegations that we'd asked for that was not put into the matrix revisions. There was no real explanation given. And CCRB has been analyzing this as an abuse of authority, threat of force, and we will continue to analyze it that way until such time as an allegation is placed in the matrix. Gun pointed, similar, we asked for it to be added as a force allegation. It was not added, no explanation. CCRB will continue to analyze this as use of deadly force with no injury under the current matrix. And one thing I just want to emphasize is that these recommendations are by no means exhaustive. We've only been using the matrix for a little over 6 months, so our sample size is very small, and we anticipate that as we continue using the matrix, more issues will arise, more allegations will arise, and we expect to have ongoing conversations among the board and with NYPD about additional changes and updates that we would like to see. So moving forward, the CCRB should continue to comply with the Memorandum of Understanding that we signed with the Police Department to use the matrix in our discipline recommendations. Staff will continue to track issues and missing allegations. We will continue to review the DCT decisions for matrix implementation. Staff will continue to monitor the concurrence rate of penalty impositions. And lastly, we encourage everyone in the public to comment on these proposed revisions. You can go, I put the website right here, you can go there anytime before December 5th when the comment period closes and make your recommendations. And that's it. I'm happy to take questions if anybody has them.
Right, if anyone does have, thank you first of all, Heather, for the presentation. And if anyone has questions, again, it's not possible to see everyone, so please just open your mic and ask any questions that you would. Now I can see a little bit better. Are there any questions or comments?
Yes, this is Frank Dwyer. To say gun drawn is use of deadly physical force, no injuries, is to equate it with a shot fired that the board thinks is inappropriate and where there are no injuries. Is that the intent? That those two are equal?
Mr. Mr. Chair, can I answer Mr.
Oh,
Dwyer?
absolutely. Yeah.
So I think we distinguish between gun drawn and gun pointed. And the reason why we asked for the additional allegation is because I think you're correct, and it is not identical. There are significant differences. And so we think there should be a separate allegation in the matrix that shows while pointing your gun at someone is serious, it is less serious than actually firing or firing. That's why we think it would be better if a separate allegation was added to the matrix so that we could better calibrate discipline and penalty recommendations.
I understand what you just said, but if gun pointed, so for example, something I've disagreed on at times is that it has been the position of the CCRB that car stops, grand larceny autos are not dangerous events. Even though when you look at the national statistics of where police officers are killed, it ranks highly when police officers are killed. But I've been told that grand larceny and grand larceny autos are not dangerous events and do not warrant guns being drawn. Now, having said that, to go back to what maybe I didn't ask, I may have misspoken. What I'm asking is a gun drawn and pointed at a person at the moment being equated with the gun being drawn, pointed at a person, and the shot being fired that doesn't hit him or her?
So gun drawn, not pointed at anyone, is not considered the same as firing your weapon and missing. But gun drawn and pointed is, for the purposes of the matrix, currently considered the same because it needs its own category and doesn't have one. That's why we continue to request the department add one to the matrix.
Say that again, John. We asked the department. You just broke up.
It needs its own category. I think Mr. Dwyer is correct. It should not be considered in that way, but it is more serious than merely drawing your weapon. Pointing it at an individual is more serious than merely drawing your weapon. If it's inappropriate, right? Like there are times when an officer draws their weapon or points their weapon, and the CCRB exonerates that conduct. So it is not always that drawing your weapon is going to be misconduct, and it's not always that pointing your weapon is going to be misconduct. But when it is misconduct, and the board is trying to recommend fair penalties for the member of service and for the civilians involved, we think there needs to be an additional allegation or row in the matrix so that you don't have to equate firing the weapon with pointing.
And I certainly agree the two are different things, firing a weapon and pointing a weapon. What I would just say is, rather than saying we have to shove everything into the matrix categories, there will always be events that don't fit. And it's more than reasonable for us then to look at the individual incident and say, it doesn't seem to fit into this individual category. Therefore, we think a fair penalty would be X, rather than saying the matrix says you're either blue or green. Therefore, even though we stare and say you are not blue and green, we will shove you into one category or another.
So I think you're right, and that if there is I forget the language now in the MOU, but if there is the extraordinary circumstance where something deserves to be deviation from the matrix, then that is something the board panel or the board, when it is meeting, should decide. Like the board has the power to do that, but it should only deviate from the matrix in the extraordinary circumstance that requires it. And you may be describing something that meets that threshold.
And that is the language. Are there any more comments, questions?
I have
Mr. Puma, and then Ms. Irish.
Thank you, Chair. Just bear with me as I try to form this question. So I guess I wanted to get an idea of how many, and this is, I guess, maybe more of a statistical question. When we talk about, these, making sure that certain allegations are included in the matrix, I think it's worth saying, I guess, for the purpose of the public record, that these are allegations, allegation categories that the CCRB has pled and investigated and made findings on in the past. So nothing is new, really, in that regard. And I suppose that the NYPD has also, issued discipline or meted out discipline in cases prior to the matrix where we had those allegations. So I guess I'm wondering if we had a case, for example, prior to these proposed changes that had, I don't know, failure to obtain language services, which I can recall over the last few months that was an allegation in one of my panels, in one of my cases, in one of my panels. Is it possible that that discipline would not be, I guess, meted out if it was substantiated, if the allegation was substantiated now under the current sort of setup?
Can I answer that, Mr. Chair?
Yeah.
That's a very interesting question, Mr. Puma, and I think it bears, I'll have to check the statistics and get back to you. I don't know that the department has closed an allegation for failure to obtain language services. While it is not a brand new allegation, it is certainly a new allegation. So far, since the board decided to follow the matrix in February of 2021, there have been 60 members of service where the board recommended discipline and the police department then had a chance to impose discipline. And so it's still a tiny number of cases where we have data on the success of the matrix in improving the concurrence rate, and we're as a staff monitoring it closely, but there's much less data than we need at this point to make conclusions like the one that you're asking. But I can assure you Hari is here listening, and that's something that we'll monitor and report back on at future meetings.
Ms. Irish.
Well, Heather, I just want to say I thought that was an excellent presentation, and to thank you for that. The last slide said that the CCRB should be following the MOU. And I think it's important to emphasize, like, for me, that's a question mark still, because we still don't have information. The MOU, the purpose of it was that we would follow this matrix even if we disagreed with it, and the NYPD would adopt these recommendations, the recommendations under the matrix that we put forth, except in unusual circumstances. And my understanding is we just don't have information on whether that is happening. At least I haven't seen it. So I don't know whether this is working or not. And I think that it's important to be transparent about the fact that we don't know whether these recommendations are being accepted, and whether all of this work we are putting in the matrix how it's bearing fruit at this point in time.
And I think that was one of the reasons why the MOU, we said we would do it to get a year's worth of data. And that's why I think I was trying to emphasize the fact that they did a 6-month update, and that just didn't give us a large enough sample size to really have the depth and the breadth of recommendations. You know, we just haven't been using it long enough to have probably fuller recommendations than what we have now, because I think even the things that we have now, you know, these are the first things that have come up in the 6 months, right? But it's by no means exhaustive, in the same way that what Mr. Puma was talking about, like there may be allegations, or even like when I was talking about body cavity searches, we've had body cavity search cases, we just haven't had them in the 6 months, so we don't know where they would go, right? So it's like we do, the reason I put that in there about the MOU is because the MOU, what we said in the beginning as part of the MOU is that we would do it in February. We said we would do it for a year, and we would see how it goes for a year, and then we would reevaluate. So this is sort of the halfway point where we realize, okay, we may not have enough data, and the situation may be different in another 6 months.
Yeah, my understanding was that we would be reviewing at 6 months, and that I'm just surprised we don't have decisions from the NYPD at this point in time.
Actually,
We
do.
We have some. I know we have some.
We just don't have
we don't have
a
lot, yeah, based on, you know, 6 months plus of work that we've done in just making recommendations. So, I mean, I think at a year, I don't know how many decisions we will have. We may be saying the same thing at a year, and that's troubling to me.
Well, let's see where we are. There's still a lot of work to be done. This is very new. I don't think it's been tried anywhere in the nation. And so let's see where we are 6 months from now. But it's a point well taken, and I think if we will have many more cases in the pipeline, hopefully many more cases that the department will have signed off on, and thus more data to tell whether or not this is actually working the way it was intended. Are there other questions or comments? Anyone? All right. Well, thank you, Heather, and we'll talk about it again sometime next spring.
Thank you. Good night, everyone.
Thanks. So what do we have next here on the agenda?
I think Ms. Simmons is on.
Sorry, yes. Ms. Simmons, would you like to introduce yourself to the public? And I lost you on my screen. I think she's gone. No, there you are. There you are. I see you. You're muted.
I am Esmeralda Simmons. I am the appointee of the public advocate, and I am sorry to be late on the screen, but I was on board trying to get on for like half an hour, and participating like the rest of the New York City folks that aren't on the board. So thank you so much, and it's been a good meeting so far.
Thank you. And sorry for the technical difficulties. We're now going to hear from community groups, and I'll ask Yahira if she'll introduce our invited speakers.
Thank you, Chair Davey. As a reminder for folks speaking tonight, please keep your comments to 2 minutes. Today, our first speaker today will be Tiffany Verrett. She's a Bronx-based program mentor at Summer Search NYC.
Is the speaker with us?
Looks like there may be some technical difficulties. While we sort that out, Soren, can you upgrade Jose Torres, Associate Director at Neighborhood Safety Initiative at the Center for Court Innovation?
Like Mr. Torres is on, if you want to turn your camera on and your mic on, Mr. Torres.
Hi, folks. How are you all doing today? I can't turn my camera on. It seems I don't see the prompt. But I wanted to thank you all for having me here. Speak on behalf of the community that we service. I'm definitely going to keep my comments very succinct. I do think as we're discussing reviewing matrices for misconduct, I do think it's also really important on how we allocate the force throughout the community. It's going to be really important, and I think it's something that may be beneficial that the hiring practices of NYPD are kind of opened up, and maybe, just maybe, that there can be an opportunity for communities to have decisions and who is actually representing them in the precincts of their communities. And so I think it's going to be it would be really important, and actually I think really groundbreaking if there would be hiring panels for these officers when they are coming into our communities. And so our community members feel that the people who are protecting them are actually folks that they've had relationships with, and they actually made that decision. As y'all can hear, I'm actually on the road right now, but I do think that that is, at least for me, someone who's been working on the ground and in an initiative that is focused on community development and community empowerment and kind of on the melding of both city and community infrastructure, that this can be a way to kind of resolve some of the questions and some of the issues that some of our communities are having in terms of the relationship, some of the relationship that is happening in our communities, right? The SEO program has worked well in some of the communities that we work in because there's a familiarity and there's a relationship there. But I think that relationship can get taken to a further elevation if there is some opening up of the hiring practices of NYPD and residents of these communities can make these decisions on who is serving in their forces. And I will leave it at that.
Thank you, Mr. Torres. Any questions or comments from board members? All right, thank you. Yahira, for our next speaker, please.
Thank you, Jose. Next, we'll try Tiffany one more time. We'll be calling in.
I don't see her on the screen, Yahira, so should we go to the next speaker?
Yes. Next, we'll be hearing from Sheehan James. She's a student and member of Summer Search NYC as well.
I see, I don't see her, but I
think Soren just needs 1 second.
Okay.
All right, I think the call may have dropped. Next, we'll be hearing from, is that, no, still disconnected? All right. Next, we'll be hearing from Tyrone Riley.
All right, Mr. Riley, you are up. You might need to unmute. Okay, go ahead. Mr. Riley? Tyrone Riley. Yari, this seems to be a night for technical difficulty. We're going to try one more time and then we'll go to the next speaker. Tyrone Riley, can you hear us? All right. I think he may not know that he's on. So can we go to the next speaker?
Yeah, no problem. Next, we'll be hearing from, I believe she's on, Karen Jenkins.
Is Ms. Jenkins there? I think we can. Ms. Jenkins? I think Tyrone Riley is still connected, Yahira. Let's see if Soren can mute him. And let's see if we can get Ms. Jenkins. All right. So should we try again? And
We can
move
try.
to. Okay, go ahead.
We'll try Tyrone one more time, and if not, we'll go proceed to public session.
Okay. Is Tyrone Riley there? I just think he's trying to speak Yahira and the connection's not very good.
Yeah, I think that sounds about right. We'll make sure to invite them to the next board meeting as well, so we can move to the public session.
All right. So we will do that. We'll move to the public comment. We need to do some reminders that if you're interested in making a public comment, please use the raise the hand feature, and we will go down the list. We'll ask you again to please keep your comments to 2 minutes. And Yahira, would you please call on the first person? And maybe we'll have a little better luck this time than we did last time. So who is the first speaker?
We have Christopher Worth.
Right. Christopher Worth, are you there?
Can you hear me?
Yes, please go
Okay,
ahead.
great. Thank you. My name is Christopher Worth. I'm a journalist with WNYC Gothamist. And I actually just have a question for the board in regards to statute of limitations for the protest complaints that came in last summer. I think we're approaching 18 months on some of those earliest cases. And I would like to know how statute of limitations will work given the various extensions that were placed during the pandemic.
So I'm going to turn to John Darsh, our executive director, to answer that.
So under the executive orders issued by the governor at the time, the statute of limitations for cases that occurred during the pandemic is May 4th. So they're all going to be coming due on May 4th.
Say that again, John.
May 4th.
Okay.
That's May 4th of 2022, is that right?
That is correct.
And Mr. Darsh, are you able to cite the specific executive orders that that make that possible, that provide that extension?
No, but we'll have our comms people send it to you.
Okay, great. Thank you very much.
Thank you. Any comments or questions from the board? All right, thanks. Yahira, our next speaker, please.
Next, we'll be hearing from Crystal Calderon.
Is Crystal Calderon there? Crystal? All right, should we try the next speaker, Yahira?
Yes. Soren, can you actually try Crystal one more time?
Hi, can you hear me?
Yes, please go ahead.
Hi, thank you so much. So I just want to say a little bit about my situation. This is going to be very vague. I've been dealing with the NYPD in Brooklyn and Greenpoint for the past 5 years over pretty savage harassment from my landlord, and that's as a result of a rent overcharge fraud scheme. So I live in a rent stabilized apartment. They've been trying to get me out for 5 years. The harassment has included racial slurs like, well, you guys know what that is, so I won't say them, towards myself, and I'm of Hispanic descent, and my neighbor is an African American. I've been threatened that I was going to be raped. I've been followed, photographed. I was sexually assaulted in the hallway of the Kings County Courthouse by my landlord. And throughout the entire 5 years, I have been calling 911 and the precinct local office number. I've had hundreds of police officers come to my apartment, and not only did they not help the situation, they were apathetic and neglectful. There was a lot of negligence, and there was a lot of misconduct. So from the police, so now moving on from my landlord to the police, I've been told that I was going to get arrested if I called the police one more time for help. I guess because I called so many times, because that's how much help I have needed. I have been told, well, asked what I was wearing to incite this sexual harassment. Even though I've been in my own home throughout 90% of the time that I've been harassed. I have been gaslit. I've been told that I that filing landlord-tenant issues are a result of something that the tenant is doing, and that essentially I could stop everything if I just move. I've been told it's my fault. My 2 minutes are up, but that's just an
So, Ms.
overview.
Calderon, we know you have a case before us. It is under consideration, so we're not going to be able to comment, but
That's
just know your case is being adjudicated.
Right. I know all of this. I just wanted the people on this phone call to be aware of that.
Understood.
Yeah.
Thank you. Thank you.
Thank you.
All righty. Next speaker, please, Yahira.
Thank you, Chair. I'll give folks a second in case they want to raise their hands. And in that time, I want to thank Assembly Member Chantel Jackson for attending, as well as staff from Councilmember Adrian Adams and the Queens District Attorney. As of now, we don't have, Rudy Racine. Soren, if you can upgrade them.
Hi, good evening. This is Rudy Racine. Can you hear me?
Yes, please go ahead.
All right. Well, first and foremost, I want to thank you all for dedicating your time to host this meeting. It's been very informative. So I'm the founder of an app, a business called Watch the Block. My business is a mobile application that allows users to rate their interaction with the police officer, and the app actually assigns those ratings to police precincts, the local police precinct responsible for policing the area that the user is in. I'm basically attending this call because I would love an opportunity to work alongside with the CCRB and see if there's an opportunity for the data that Watch the Block collects to support your initiatives. I know outreach is sometimes a challenge. So just curious to see how Watch the Block can align itself with New York City's CCRB and assist with providing accountability, but also tracking the positive success stories with officers in the community, as well as the negative stories where officers might be abusing their power.
We'll ask Mr. Darsh to have the appropriate staff be in touch with you. John, you want to comment any further?
Yes, Mr. Racine, I'm going to ask Jahai to get your contact information, and we'll have someone from our information technology unit reach out to you and set up a meeting.
Excellent. Thank you so much.
Thank you. Any other speakers, Yahira?
That concludes our public portion.
Great. Thank you. So now we are going to move into executive session, assuming there are no further comments from board members, questions from board members for the public. All right, we will move into executive session. The agenda for the executive session is that the board will deliberate on a full board case. We're going to receive an update from the executive director and the general counsel. And the executive director will discuss the following items: scheduling issues for panels and full board cases, update on cases and status of investigations, update on pending personnel actions, and COVID-19 protocols for board members and staff. The general counsel will discuss the following: update on rules litigation, and update on current litigation. Is there a motion to adjourn to executive session with these items as our agenda?
So moved.
Is there a second? It's been seconded.
Second.
Comments? All those in favor of adjourning to executive session with this agenda, please say aye.
Aye.
Aye. Any opposed? Ayes have it. We will adjourn to executive session. We will remind the board members that there's a link for another link for executive session. So we will see you shortly. Thank you to the public, to everybody who turned out, and we will see you next month. We'll now go to executive session. Thank you.